The notice of disallowance of claim. Hi, I'm Darren Findling of the Probate Pro. We're going to examine the creditor process and the notice that is used to disallow a creditor claim in the probate court. We're referring to a SCAO form. That's a state court administrative order form. In this case, on the bottom left corner, you'll see it's pointing to PC 580. PC stands for probate court. So this is PC form 580. If you need this form, you can of course Google it or contact my office. We're happy to provide one free of charge. So with all of these state court administrative order forms, the court rule and statutes are identified in the bottom right corner. And there's a few of them here. I'm going to hover that arrow to show you that these statutes govern the basis for the use of this form. Now, this form can be used in a probate or trust administration process, as well as within a guardian and conservatorship estate. So it has both use in probate administration as well as guardian and conservatorship administration. So when would it be used? Well, let's look at the statutes that are referenced in this particular form. 700.3806 is the allowance and disallowance of creditor claim process. And the idea is that in administration of an estate, there's an orderly process that allows the personal representative to give notice to known creditors by sending them a particular notice that is expressed in, or explained in another video that I've done, as well as publishing for unknown creditors. And again, that process is explained under another form within another video. But once that noticing goes out, creditors will start identifying that you or the estate may be obligated as a creditor, meaning the estate or personal representative or conservator owes money to another party. That party could be an individual, it could be a medical provider, it could be a credit card company, it could be anyone. But those creditors are going to send proofs of claim, another form that is explained in another video through YouTube. You can check it out. But once that has occurred, these creditors are submitting claims. The fiduciary, the personal representative, trustee, guardian, or conservator can say, I allow it, meaning I'm accepting the creditor, we're going to pay it, or I'm going to disallow it. This form is the notice of that disallowance. And under 700.3806, the fiduciary can disallow the creditor claim. Now, of course, the benefit of disallowing it, or the reason that this is so critical, is once the disallowance occurs, a clock starts ticking for the creditor. The creditor then has 63 days after the mailing or delivery of that notice to do something. It may be, generally, it's the filing of a lawsuit, a complaint within the appropriate district, circuit, federal, or probate court to sue for that claim. Filing a petition is generally not a basis for perfecting a creditor claim in a deceased probate estate, but you have to file a civil action, and that's what that clock provides for. And a failure to do that within that 63-day period absolves the estate of liability. So it's a statute of limitations. It in essence says you, creditor, failed to perfect your claim by suing within that time frame. And by failing to do so, you are forever barred. You cannot come after the estate or the personal representative after that time frame if you fail to file your suit within time. So it's really critical that if you're a recipient of this notice of disallowance, that you act on your rights very quickly, or the tolling may occur and you will forever be barred to collect on the debt. In addition, when use of this form, the statutes provide, both 700.3806 and 700.5429, that the personal representative can first disallow and then back off. They can say, now we're going to allow it. So a lot of power is vested in the personal representative or conservator. They can disallow and then say, oh, we'll allow it. Provide us additional proof that the debt is owed. So for example, a proof of claim may come in and the personal representative doesn't recognize the debt. They may not even know if it's for the right person. So they disallow the claim, and then the creditor may provide additional supporting information, and the conservator, personal representative, can say, I'm now satisfied. I'm going to allow the creditor claim. In addition, under these statutes, as well as 700.7611, which applies to revocable trust, it provides that the claim can be disallowed in whole or in part, meaning if there is a claim, sometimes the proof of claim has many different debts or one lump debt, and the personal representative can say, well, I agree to a portion of it in part. I'm allowing part of it, but not the whole. Now, we don't see that happen that often, but it does happen and arise in certain circumstances when the creditor is making a claim larger than the personal representative believes is appropriate. So then we see them disallowing the creditor claim in part rather than in its entirety. So let's work our way through this form. Now remember, it generally has occurred after a creditor has made a proof of claim, making a demand that a debt is owed by a trust, a probate estate, a guardian, or conservatorship estate. Top left corner, the probate court upon which the matter is pending, or if it's a revocable trust, the county in which the trust is being administered is referenced in the top left corner. In the top right corner, if there's a case number, and usually there is for these matters that are being supervised through the probate court, it would be referenced there. As you work your way through the document, the estate of is simply the name of the estate. It's a guardian, conservatorship estate, deceased estate, or trust. That's referenced in that line. And then the section that has that little mailing section with those brackets, that's the name of the creditor that is filed the creditor claim. Now, it's important to understand that often creditors are managed by servicing agents. Sometimes debt is sold to a third party. So it's really important that that section is identified correctly, because if you want to correctly disallow the creditor claim, you have to match the party that is asserting the debt and give them appropriate notice. So for example, if a third party servicing agent is identified in the mailing, you have to be able to discern, are you giving notice to the servicing agent or the party that holds the debt, or maybe both? The brackets are there because this form was designed so that you could trifold it and then stick it in a clear envelope. Most people don't do that, but that's the reason for that space with the bracketing. As you move further down in the form, you'll see that you're identifying the date of the proof of claim or the date that the debt was asserted. Maybe it's a bill and not a traditional statement and proof of claim under a SCAO form, but just a bill that has been asserted and the amount that you're disallowing. So here, this is the part where I spoke of you can disallow it in its entirety or in part. The next section, there's a checkbox that talks about the entire claim or a portion of the claim has been disallowed. Now this is the notice part, and this is why the form is so important to use, because I've seen people disallow creditor claims by writing letters. And if you don't specifically assert the statutory bar provision as referenced in the statutes in this form, it doesn't constitute a bar or a statute of limitations bar. So let's explain that and kind of unwind or unpackage that a little bit. So the form itself gives notice to the creditor that they have 63 days to act. They have 63 days from the date to file that lawsuit to perfect their claim or be forever barred. But often people will call me and they'll say, well, I sent them a death certificate. That doesn't constitute a disallowance of claim. Or they said they're not going to come after me because I sent them a letter saying we don't have any money. Those letters or mailing of a death certificate or simply a creditor saying, don't worry, we'll write it off, that does not constitute a tolling of that statute of limitation. It doesn't bar the creditor from coming forward once the estate is open. So the mere sending or sending creditors death certificates is not the process to create a disallowance of the creditor claim. You have to do it as referenced under the statute. And this particular form allows for those particular requirements to be identified. So I always encourage people to use the form because in this particular case, it will allow for the statutory bar after the 63 days to ensure that the estate is absolved of liability because the statute of limitations will have expired. As you move further down the document, the fiduciary's information is identified there and the signature of the attorney is identified there. That little date section is also important because that date and then the proof of service spot is the date upon which that 63 days starts clicking, or the clock starts winding from. So once that date's on there, 63 days should be calendared, and after that 63 days, the debt is wiped out. It's erased by virtue of the statute of limitations. So you fill out that proof of service, you identify whether you did it by first-class mail or if it was delivered. Sometimes it's delivered because it's a family member or a neighbor, but usually first-class mail is used. And then, of course, the penalty of perjury clause. The clause that says, I promise I'm completing this form under the penalties of perjury, that it's being done under the best of my information, knowledge, and belief, and then it's signed and dated. Now, if you notice, there's a use note that is in small print. It says, if this form is being filed in the Circuit Court Family Division, please enter the court name and county in the upper left corner of the form. Again, this can be used in a variety of contexts and to really understand the nuances of this form, because I've identified both deceased estates, revocable trust, guardianship, conservatorship, and a variety of statutes. To really understand the full extent of the use of this form, you should talk to your probate practitioner, contact my office. We're happy to provide additional guidance on the use of this form. But the notice of disallowance of claim is really a critical, important form in the effective administration of an estate to bar creditors, so that when you're done administering the estate, you can be assured that you don't have creditors that are going to come out of the woodwork and claim that you failed to give them appropriate notice. At the Probate Pro, we're passionate about probate-related issues. If you have questions about the notice of disallowance of creditor claim or any probate or trust-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.